Hello, Michael Petrellis, gay blogger. I have a question for Chad, and it has to do with any influence you hope that will come out of this decision that will affect both the other professional gay advocacy groups, and do you have any hope that this decision and all the fights that you've been waging through the decision are going to influence the activist groups, many of which you know sprang up after we lost in November of 2008. And I'm just wondering what your feelings are about how the professional groups and the activist groups can use this whole fight and the decision for the betterment of America.
Well, first of all, today's victory is not our victory, just those of us on this stage. It's the victory for everyone. And as David said, we wouldn't be here today were it not for the advocates, some of whom are still with us and some aren't, over the decades that have brought us to this decision today. And without them, we wouldn't be here. And those organizations who've been fighting this battle for so long, who are supportive of us in this case, we look forward to working with everyone until we have full and complete equality under the law. And gay and straight people alike, advocates and not, can celebrate in this decision today because it is the utmost of American decisions.
You've mentioned several times that this is one step on many in a legal fight. What would you suggest that to folks who are pursuing putting this on the ballot in 2012 in California? Should they stop? Should they continue? What's your advice to them?
I can only talk about what this organization is going to do, and the millions of people who've signed up online and on our website and are following this organization. And our mandate and our goal is very clear, and I don't want to be in the position of suggesting what others could or should do. As you know, this is a victory. It is said that it was unconstitutional, and I think we should celebrate in that victory, and we should move forward and do what's necessary in the higher courts, as was just discussed. But I, for one, don't believe that a fundamental constitutional right should ever be put before a vote of the people or be before politicians. This is the place that it should have been decided, and that's in a federal court of law where the Constitution protects every single American.
I want to say one more thing with respect to that. This trial has helped to educate the people of this state and the people of the United States. People who have watched this trial and listened to the witnesses, and the people of the United States who will read this opinion and who will teach this opinion in law schools and in civics classes, will gradually and continuously, I think rapidly, begin to appreciate the damage that we've done to our citizenry, to our nation, by this discrimination. I feel attitudes changing rapidly in the direction against discrimination and against measures like Proposition 8 throughout the United States. So, and we're not giving any advice to any political group or any organization that wants to bring something to the ballot, but we feel very good about the fact that people who have watched this trial have said, oh, that's what it's all about. Why would we withhold the opportunity for loving people to be married? Why would we do that? People are changing, and it's changing rapidly.
A question for Dennis Herrera, Margie Schaefer with KCBS. Just the interpretation of the stay and then San Francisco's response to the stay.
Margie, I think you heard David and Ted talk about the importance of expediting things as quickly as possible while also recognizing what Judge Walker has done with respect to the stay and how he wants to proceed. From our perspective, I would agree with Ted and David 100% that we want to do whatever possible within the confines of the order that Judge Walker has issued to make sure that the decision is expedited both through the district court and through the Ninth Circuit as quickly as possible, because we are talking about people's fundamental rights. And that is something, the constitutional protections are not something that we should delay, something that we should try and rectify as quickly as possible. And we are going to work within the confines of the order that Judge Walker issued to make sure that we get this dealt with as quickly as possible.
For those of us who haven't had an opportunity to digest or actually even see the decision yet, for someone who has, if you could do us a favor of characterizing the judge's conclusions about the proponent's case.
What the judge did, and I do hope that everyone will have a chance to read it from the first word to the last word. The judge very carefully, not just with respect to the proponent's case, but to the plaintiff's case, carefully analyzed the 8 or 9 witnesses, lay witnesses that we put on, including the plaintiffs, and the 9 expert witnesses that we put on, found all of those experts and all of those witnesses credible, qualified, and that they told the truth and they carried great weight. On the other hand, the judge pointed out that most of the witnesses that the proponents had proposed to bring to this trial were withdrawn at the beginning of the trial, and that 2 of the witnesses that they did put on wound up agreeing, thanks to David's very gentle cross-examination, gentle but persistent cross-examination, agreed with most of the propositions that were being advanced by the plaintiffs. And David even brought in, or we did brought in, and thanks to David again and members of our team, deposition testimony that was on videotape of witnesses that they did intend to bring to the trial, who wound up agreeing with many of the propositions that we were advancing, and then for some reason they didn't bring them to the trial, knowing what it was like to be cross-examined by David Boies. So what the judge did was carefully examine the witnesses and evidence on each side of the case, placed a value on the evidence that was brought by the plaintiffs, placed very little value on the evidence that was brought by the proponents of Proposition 8. In fact, their principal witness, the judge found, number 1, was not qualified to testify as an expert witness, and every opinion that he offered did not carry any weight as far as the judge was concerned, because those opinions didn't make any sense. So it's a very thorough examination of not just the legal issues, but of the factual issues as well.
Hi, I'm Patrick Connors from SF Weekly, and the National Organization of Marriage says that this ruling jeopardizes the marriage laws of 45 states, threatening to strip millions of Americans of our core civil right to vote for marriage. How do you respond to that?
This decision strips no one of any rights. This decision grants rights to be married. As the court held, there is no harm to anyone's rights as a result of this decision. In fact, it increases the stability and the value of marriage to our society. There is no legitimate interest of the state in discriminating and continuing to discriminate against this group of our citizens. That's what the facts were demonstrated to be. That's what even the defendant's witnesses admitted, and that's what the judge found. And I want to just echo one thing that Ted said, and that is everybody ought to read this opinion. It's long, but it's clear, and it sets forth the record on the facts and the law that everyone in this country who cares about this issue ought to think about. And I would challenge anybody who's putting out those kind of press releases to read this opinion and then tell me what they disagree with, what they have left to say. Not to just ignore the opinion, but take a look at this opinion, because it is a careful, thorough analysis of why this discrimination is so anti-American.